Hey y'all, I'm Ada K. And I must confess, I'm a trial junkie. I enjoy viewing trials as if I was the seated juror. So grab a cup of java, get comfy, and join me as we hop into court. And don't forget to comment, like, and most importantly, subscribe. And if you're really enjoying the channel, please join our membership. Welcome to yet the second day of the Black Swan trial. And guess what, guys? We got the inside scoop. I'm so excited. I got to get this out of my ear. Sorry. Woo. The echo is bad. You guys, I'm so excited. I can't begin to tell you. We have an inside scoop. We do. We have a big inside scoop. Yep. Y'all ready for this? We have the infamous Jules, who's in the courtroom right now. And she's going to be giving us all the behind the scenes stuff, like what are the jurors doing? Hi, Jules. We're talking about you. Whoop, whoop, whoop. We love you. Before court starts, I got to run a few things. I got to take care of some business. Oh, Doug Benefield's cousin has entered. Ooh, we are so excited. But I'm excited for multiple reasons. But already, y'all saw it yesterday, and it's true. Are you ready to win? July has been an amazing month. And to end the month, we're doing a subscription campaign. And if you want to win a free Starbucks tumbler, just click the subscribe button. That's it. It's easy. Then leave in the comments, I sub, so we can get you in the drawing. The winner will be announced July 31st. Good luck, everyone, and thank you for subscribing. Yes! Isn't that awesome? Oh my gosh. Prosecutors haven't, no protesting outside. That's good to hear. No little girl outside, Jules? No little girl outside holding a sign? Oh my gosh, that was so horrible, y'all. Seeing that little baby girl sitting there holding a sign all day. That sounds like a plan, Miss Jewel. We'll take it. Thank you so much, Miss Jules. Oh my gosh, it is so cool to have an insider. An insider! Go figure! Oh, we moved up in the world. We got Jules. She's such a sweetheart. I really, really, really appreciate her. Oh, I forgot. Oh, this Google thing is driving me. All of a sudden, Google is hopping up. Stuff is hopping up and it shouldn't be. So let's quickly go through. And we got to get the birthday in. I'm going to come over here, move it so I can see. Get rid of that. Let's do the birthdays real quick. Real quick. They're very important. If you have a birthday, it's important. Let's go. Happy birthday to you. Happy birthday. Happy birthday. Happy birthday to you. Well, happy birthday to... I lost it. Let me get it back up here. Brandon. Oh, Christy, happy birthday. Joseph, enjoy your family today. Sandy, hope it's a blessed birthday. Kim, oh, looking gorgeous doll. Sienna, happy birthday. Love that little kitty. She's gorgeous. Kim, happy birthday. Terry, happy birthday. I hope it's awesome. Michelle, Happy birthday, Angie. Oh my gosh. The big 5-0. Happy birthday. Ben and Pearl, happy birthday. Reagan, happy birthday to y'all. I hope y'all have a great and blessed day. Oh my gosh. Erica, I sub, thank you. Whoop, whoop. You're in the drawing. You're in the drawing. Oh my gosh. Welcome everybody. See Morales peeps. Hi, thank you for joining. Oh, we have Jules. I'm so excited. We've got Jules, glorious Jules. Oh my gosh. Well, the thing is that's so awesome is when you have an insider like this, you get to see and get to hear, not see, hear some of the new stuff that maybe most people don't get. Like, how are the jurors behaving? Hi, baby girl. How are, I'm getting all my stuff lined up. I mean, it's just simply amazing. So let me give a call to our interpreter and see if she's available today. She's so kind to fit us in her schedule. Hold on. And I'm off. Sorry about that. You should have told me, mic off. I know. So anyway, I was talking about Miss Jules, how famous she is because she was at the Maya trial and was in on all the skinny at the Maya trial. And then she became friends with Maya and the family and Dr. Joe. And I don't know why my camera keeps somehow on its own, it's naturally moving and I don't know how it's doing. So thanks, guys. I'm not awake early this morning. This is usually when I'm barely getting up. But anyway, Dr. Joe and her became friends, and she became very famous during the Maya trial. Well, she is now a good friend of mine, and I'm the honored one to have her and be able to call her as a friend. And so she is going to be sitting in on this trial today, and she's going to be giving us the tea on the jury, their reactions. She's going to talk about what she sees in court. So it's going to be awesome. Yes. Thank you, everyone, for being here. We have a great Discord group. In that Discord, we have um, new unread threads. Oh, cool. We have a member chat. Since they go place, we have a members chat where you can just sit and hang out and chat. Let's see. 3 members of the Massachusetts State Police with links to the high-profile Karen Reed murder trial, which resulted in a mistrial early this month, are facing internal affairs investigation. We're going to talk about that on our lunch break. Definitely, we're going there on our lunch break. But then you also get the ADA's quarter, which I've got to go post on. You also get connection to the ASL interpreter if you'd like. And of course, breaking news. So we got some Discord going on, and you can chat with me. You can connect with me, my mods, anybody. It is open to everyone. So please come join the Discord group. Oh my gosh, y'all. I'm excited. I think my energy is much better this morning, right, Miss Kevin? And I forgot. We cannot leave out my very first sponsor. Word from my sponsor. Oh my gosh. And I'm being blessed right now. Hey, y'all. I am so excited we have our very first sponsor, and I'm wearing this hat to honor them. Who is it? Well, it's coffee, my favorite thing. This coffee is from Hitchman Homestead Coffee. This is the Shooter Shack Coffee Pioneer Nicaraguan Roast. This coffee is so delicious, y'all. It is so smooth. It does not leave a chemical taste on the back of the tongue. It's not overly bitter. And I have to tell you, it is my favorite. And I am now getting rid of all my other coffee. I kid you not. They have a monthly subscription available. You get 4 12-ounce bag a month, either whole beaned or ground. And then you can also get a Keurig option as well. The other thing they have is wonderful gift boxes that you can send to your loved ones. So you want to support a fabulous home business and people here in the Hill Country, go to hitchmanhomestead.com and let them know I sent you, and grab yourself some of the best tasting coffee we have here in Texas Hill Country. Yay, the Texas Hill Country. Those of you who don't know, we went through some big rainstorms and flooding yesterday. I lost my live, but one thing about StreamYard, it kept it going because it's not connected. I mean, if my computer goes down, it's still live. And Miss Kevin was able to hop on and throw the stream back up for me. For those of you who don't know, Miss Kevin is not only my mod, but she's the mod boss. Yeah, she's the boss. No, I'm kidding. She's fabulous. Miss Kevin, you are awesome. I love and appreciate you, as I do all of our mods. And I'm looking, do we have any other mods on? No. And Riel was on earlier this morning. I don't know if she still is. There's Miss Jules right there, their long hair in front of the guy with the blue. Oh, Miss Jules. There she is. Miss Jules. Yep. Oh my gosh, there's Miss Jules. So, oh, poor baby. Well, we got her. We got her. How do I say that? Hello, Brit. Hello, it's Brit. Thank you, Miss Brit. I'm going to say hello, Brit. I hope you don't mind. I am sorry. I'm just dyslexic and some things are hard. But yes, Miss Jules is sitting just off to between the defendant and her lawyer in the back over here. I'll click on it so you can see. Oh, didn't mean to do that. Where my little mousey is, she's back over here. So we'll get some views of her. But it's Jules. Now, I have to say, she's not just, we're not the exclusive. RA is exclusive too. But I've never had anybody in the courtroom for me. Not for me. In the courtroom giving me the tea. I like that, spilling the tea. I think that's going to be her second catchphrase. What do you think? We have, in my humble opinion, IMHO, and the other one is spilling the tea. What you think? So, anything else we need to take care of business-wise? I'm trying to look. I think we're good. We's good. I'm going to put on a little bit of. Oh, no, I'm not. Am I? We do not have sound yet in courtroom, so don't worry. It's not you. This judge has got the patience of Job. I would have gone off on these attorneys. I really would have. There is the daughter of this decedent, the older daughter. The younger daughter was standing outside picketing signs yesterday. Oh, gosh, sorry. Yes, I got falsies on today. Hey there, Miss Ronnie. Ronnie is another one of our fabulous mods. I couldn't do it without her. I call her my research mod. Why is this giving me so much trouble today? There we go. Yes, I put falsies on today. Welcome, everybody. Okay, for those who don't know, she has headphones so she can hear what is being said when they go up to the bench for a sidebar. So come on, Judge, let's get going. I got my coffee. I got my beautiful cherries. Oh, I'm almost done with them. I'm going to be sad when I finish my last cherry. I love cherries. That is one of my favorite things. I can't do the maraschino cherries anymore. Now that I know they're in something like formaldehyde. Okay, this here, that gentleman with the long hair, that is the cousin. That, I believe. Is he the cousin? Yeah, I think he's the cousin. Looks different when his hair isn't all pulled back. Judge is bringing in the jury.
Bring the jury.
All rise. So, y'all ready? You ready? Yes, he testified yesterday. There's Miss Jules. And she has a good view of the jury. Miss Jules is feeling better. She had COVID. He's a kid, loved him, but now, no. Give me the real deal. I can eat a whole bag of those in one setting. Almost did give me a bellyache yesterday. Hi, Jules. Whoop, whoop. Hey, Jules. I'm waving. Hey, babe. She looks good. She drove an hour and a half to be there this morning through traffic, and it'll take an hour and a half to get home. And guys, be on the lookout for a pop-up live tonight.
Sure we got the right notes
Exclusive
in the right place.
pop-up live.
Your pen, sure they still got plenty of ink.
Can y'all hear, or is it me?
All right. Good morning, everyone. I just want to make sure that nobody began discussing the case amongst yourselves or.
Why is that not disappearing? Thank you.
Nobody discussed the case last night or this morning with anybody outside of the jury.
Nope.
Nobody approached you or talked
good
to you or tried to
Jules.
influence you in any way, and you didn't do any research on the people, places, things, or legal topics we've heard anything about.
Doesn't she look cute?
She says no, thank you. When we finished up yesterday, the
I forgot my
state
blush.
is still presenting its case. So, state.
State called Alicia Byers.
Alicia Byers is being called.
solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Good morning, ma'am. My name is Judge White. I'm presiding over this case. As the deputy said, just make yourself comfortable in that chair. Scoot up just a little bit. We need to get you about 12 to 15 inches from that microphone. It does adjust up, down, left, right as you need it. If you speak in a loud, clear voice right into it, it'll pick up everything.
Thank you.
Yes, ma'am.
Good morning. Please state your name.
Alicia Byers,
Can you spell your first name and last name, please?
ALICIABYERS.
And your relationship to Ashley Benefield.
She's my daughter.
And when did she start living with you in Florida?
How did she spell her first name?
I can't clearly remember.
Okay. Was there a time when Ashley moved in with you when she was pregnant?
Yes.
And she was married at the time, but it was just Ashley that moved in.
Yeah, he brought her down.
Okay.
And yes, and yeah,
And she moved in with you.
yeah. He told me I needed to take care of her. He dropped her off.
Okay. So she stayed with you from that time on, correct?
Yes.
And does Ashley have a concealed weapons permit?
Yes.
Does she own firearms?
She doesn't now, no.
Did she own firearms then?
Yes.
Okay. How
Thank
many?
you.
2, I think. Yeah, 2.
Did she ever go to the firing range or anything?
Yes.
I'm sorry.
Yes.
Okay. How frequently would she go?
Well, we did all the courses to get the concealed carry, and I don't remember.
Okay. And very shortly before the shooting, she went to the shooting range with your neighbor, correct, John Fantz?
I don't think that was close to that time, no.
So it may not have been close in time, but they have gone together? Ashley and John Sands.
I'm not sure.
Okay.
I don't know.
Okay. And
She's
you
so
and your
nervous.
daughter obviously are very close. You live together, just the two of you, right, for a
Yeah.
while.
Mhm.
And then once the baby was born, the baby lived there with you,
Correct.
correct? Okay. And around that time of the shooting, were you planning to move to Maryland?
Yes.
And you had a house that you inherited in Maryland?
It was the house I grew up in.
Okay. And you inherited that house?
Yes.
So your plan was to move to Maryland with Ashley and Emerson, the baby?
Mhm.
And Doug, Ashley's husband, was also moving to Maryland?
He was moving somewhere else. He was, yeah.
Okay,
He had found his dream job.
so he was moving to Maryland, but not moving into your same house?
Correct.
And he was packing up to move at the same time you were?
I assume so, yeah.
But he was coming over to help
Yes.
you move?
Yes.
And on a regular basis, almost every day, he was at your house?
Maybe the last week.
Okay,
Yes.
helping move boxes and things like that?
Yes.
And you all rented a U-Haul, right?
Somebody rented a U-Haul. I don't know who.
It was in your driveway though, correct?
No, it was not my driveway.
The day the shooting happened, was it in your driveway?
It, I think
If you don't
the
know, that's
U-Haul
okay.
was getting there when I was leaving.
But you also had a pod, one of
Correct.
those
That was in my driveway.
in your
Yes.
driveway? Okay. On the date of the shooting, what time did Doug get to your house? Do you remember?
No, I mean, it was, I can guess, maybe like 5 or something. I don't know.
So it was still light out?
Oh, yeah.
And maybe in the afternoon sometime?
Yeah, I don't clearly know.
Okay. So when he showed up, what did you do? Did you stay there or leave?
I was leaving when he pulled up.
And where did you go?
We went to the park.
Okay. When you say we, who is we?
Oh, Emerson and I.
Okay.
Yes.
So just you and Emerson, and
Yes.
how old was she at the time?
So I guess 2, maybe. Yeah.
Approximately.
Yeah.
And at the house, was it just Doug and Ashley then
Yes.
when you left? And you've obviously been in contact with your daughter almost every day since the shooting, correct?
Leading. No, I will roll.
You've been in contact with her basically every day, correct?
Not
the-
initially, no.
For the last several years, you've been in contact with her every day.
Well, yeah.
Okay.
I
And
don't know how to, okay, yeah.
did she ever, during any of these conversations, tell you what happened when she had to shoot Doug?
Never.
When you came back from the park, I'm assuming she was already in the squad car or she was already with law enforcement?
I had no idea where she was.
I'll sustain.
Okay. So at the time that the shooting happened, she didn't tell you what happened,
No,
correct?
we've never talked about it.
And
No, overruled.
to this day, you've never talked about it?
No.
Thank you. No further questions.
Cross.
Did she just say cool? Sorry, I'm
Morning, Ms.
doing
Byers.
paperwork. I got to get my
Very
ducks in a
nervous.
row.
Yes, very.
Scared?
Yeah.
All right, just try to relax. If my questions aren't clear, please just ask me to repeat it.
Okay. Thank you.
Was there ever a time when you and Ashley resided here in Bradenton, in the home, that Doug lived in that house?
Never.
Would it be safe to assume, and perhaps you can enlighten us a little bit, how was your relationship with your granddaughter, Emerson?
Oh, very good. Yes,
Okay.
we're very close.
And would you try to spend time with her?
Yes,
Would that include you taking her somewhere on a regular type basis?
yeah,
Would that be to the park?
yes.
And tell the ladies and gentlemen of the jury, Ms. Byers, how often you engaged in that practice of you and Emerson going to the park?
Usually several times a week. And we'd go after it cooled down because the park is not a very good, tree coverage. So it was very hot. That was the only comfortable time to go.
So we think trying to avoid the heat or
Oh, yeah.
minimize it, it'd be later in the afternoon,
Yeah, it was brutal out there otherwise.
Yeah.
Florida,
almost as bad as it is now.
Right, exactly.
Please. Live in Texas.
How far away was the park?
It's a short walk. I mean, we'd always walk over there. So I
Mhm.
don't know, take us maybe 5 minutes to get there.
Okay.
So
And on this particular day, I think you told Miss O'Donnell, if I'm not mistaken, you were actually in the process of going with Emerson to the park when Doug arrived.
yes, we're walking down the driveway and I had her in the stroller.
And on this particular occasion, there was nothing unusual about you going to the park, just
Oh,
like
no.
you
No,
did
but when-
regularly.
Yes.
Give me a moment, Your Honor, please. I believe that's all I have, Your Honor. Thank you, Ms.
Can you redirect?
No.
Oh, hold on, Dan, don't get up yet. No redirect.
Yeah.
Can this witness be released?
Yes.
Yes.
Ma'am, you are released from your subpoena. Your, the rule of sequestration had been invoked, but you're now released from your obligation.
Okay. All right. Thank
There
you.
you go. Thank you.
Judge, I apologize. In consulting with counsel, I do think I want to leave her under subpoena.
All right.
Sorry.
Ms. Byers.
So what does that mean?
I'm going to explain that.
Okay.
All right, so what that means is you remain under subpoena and subject to being recalled at the trial.
Okay.
The attorneys at the beginning of the case invoke what we call the rule of sequestration. So the instructions I'm going to give you are similar to what you've already probably been told by the attorneys. You're not to discuss your testimony here in court, the questions asked of you with anyone else, including the attorneys. You can't talk with other witnesses about what their testimony was or the questions they were asked. And it's my understanding this may be online. You are prohibited from watching anything that's going on within these four walls, ma'am, until you're released from your subpoena or until the jury comes back and you're further things. Okay? All right, thank you, ma'am. You're free to go for now. All right, State.
State will call Barbara Russell.
Oh, this way. There you go.
You solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth. So help me God, I do.
Good morning, ma'am.
Good morning.
My name is Judge White. I'm going to be presiding over this case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches away from the microphone. It does adjust up, down, left, right, however you need it. But if you just speak directly and allow your voice into the microphone, it'll pick up everything.
Thank you, sir.
And please state your name.
Barbara J. Russell.
Can you spell Barbara Ann Russell?
BARBARARUSSELL.
And what is your profession?
I'm a licensed clinical social worker. I have a doctorate in clinical psychology, and I work as a clinical and forensic mental health professional.
And how long have you known Ashley Benefield?
I've known her since April of 2020.
And when you first became involved with Ashley, it was on a professional level, correct?
Correct.
All right. And then since the time that you had that interaction, you have stayed in touch with Ashley.
Correct.
And subsequent to the shooting that happened, she actually moved into your house, correct?
Correct.
And who all lived at the house?
Myself, my husband, and my 19-year-old daughter.
And approximately how long did she live at your house?
Approximately 8 months.
And you would see her on a daily basis?
Pretty much, yes.
Okay. Did she, when you first spoke, when did you first see her or speak to her after the shooting?
About 1 o'clock the following morning.
Okay, so this happened in the evening time, so it would have been 1 o'clock the next morning. And at that time, did she say to you, "Oh my God, he came after me, I had to shoot him"? Did she say that?
She didn't discuss what had happened at all, nor did I ask.
Okay. And to this day, are you still in contact with her?
Not that one. I'll overrule on that question.
To this day, are you still in contact with her?
Yes.
Okay. And to this day, has she ever told you what prompted her shooting, Doug Benefield?
She never gave any kind of narrative of what prompted the shooting. My understanding is that
I
she was
just want to know if
defending
she
her life.
told you. I just want to know what she told you. She did not tell you anything, correct?
She never gave me any narrative about what had happened.
Thank you. No further questions.
Cross, sir.
Good morning, Dr. Russell. I have a question from your own personal knowledge. You're aware that Ashley's lawyers instructed her not to discuss the facts, correct?
Of course, any good lawyer would do that.
Oh, look at the smile on her face.
Give me just a moment, Your Honor.
I don't
Yes, sir.
trust her.
Did there come a time, Dr. Russell, when a detective,
Welcome.
Warren, contacted you about the case?
Yes.
Did you have discussions with Detective Warren?
I met with him once, yes, for about 90 minutes.
And in that meeting, did you relate to him that,
Objection.
I'm asking a question to this witness,
Well, I understand, but if it calls for hearsay, once you approach, so I can hear what the question is going to be.
Wow, y'all. Where's my jet? There's my counter. So I don't like this woman. Don't like her too much. I don't know. She just doesn't set well with me. Just creepy. My humble opinion. Doesn't mean much. 43. Okay. So why? Why did he change it? Why? Oh, good change. Yeah, good change. I love RA's thumbnails. Very creative. Love it. She just gives me a creepy vibe. Sorry. Not. Oh, my band's twisted my hair. So I wanted more from the mother. I did. I don't understand. I wanted more. They're not diving into questions. They're just vague. Why was she even there? What was the purpose to have her? I want to ask, why do you have that little girl picketing yesterday? Yeah. I think she's more objecting over the way. He's been leading. Definitely been leading. So, and he's calling for hearsay. Yeah. The question before was leading. Oh, I don't know if you heard that. Thank God it happened. What? I would have asked about her upbringing. I would have asked about a lot of her things. I don't understand. Welcome, Miss Diane. Good morning. So, that's right, we are on cross. I'm sorry, you're right. You're right. My bad. He's allowed to lead. So, leading the witness in the questionings, I keep forgetting. Everyone says, good morning, Miss Di. Yeah. Why didn't you ask questions like, how was their relationship? Did you see anything unusual? Did you notice any bruises? You were around your daughter during that time? All of that. Why did they not ask her? Oh, they said, good morning, Miss Beautiful Di. Good morning. Thank you. Just
When you spoke to Detective Warren Justin, you identified yourself.
Correct.
This was a face-to-face conversation.
Yes.
If you were to tell us today in court
fix your hair, love.
about the discussion you had with
No.
Detective Justin,
The
would
defendant.
it be any different than what you told Detective Justin on that day?
No, of course not.
So talk to her.
You have an opinion, do you not?
Objection.
Rephrase. As you sit here today, do you have a conclusion?
Objection.
Really?
Sustained.
All right, give me a moment.
Please needs to come out of his mouth. Give me a moment, please, Your Honor. May I have a moment, Your Honor? I'm stuck, Your Honor. I need some guidance from my team, Your Honor. Hi, Miss Jules. My client is guilty, Your Honor. We know she shot him. Just, it's not to stand your ground. Doop, 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 doop. Can't go any further. I might get a hit. Y'all, this is so slow. Yeah, I don't like the smirk.
Russell,
That's what threw me.
you had an opportunity that morning, from what you had to say at approximately 1 o'clock, technically the next day, to observe Miss Benefield, correct?
Yes,
I'm going to pass you a picture that's previously been marked as State's Exhibit number 21. Picture of Ashley Benefield that was taken on the day of the incident.
yes.
May I approach you on it?
Yes.
Do you see any bruising? Does it appear that she's been in an altercation?
Does that picture reflect any swelling to Ashley Benefield?
Objection, as interpreting the picture.
Sustained.
Did Ashley Benefield look like that when you saw her prior to the day of the homicide?
Prior to the day, no.
Okay. What was different about her?
When I saw her after the incident, there was edema, swelling on the side of her face.
Okay. And did that include her right eye,
It included her left eye.
left eye rather?
Yes.
Okay. And when you saw her before the homicide, did she have swelling on the left side of her face, on her cheek and her eyelid?
She never had, no.
But that wasn't dictated in the picture
fact,
they took that day
When you
or
saw
the other
her
day.
immediately following the incident that morning at about 1 a.m., was there any indication that by Ashley that her head was hurting?
Objection, hearsay.
Sustained.
Spontaneous statement, Your Honor.
That existing mental, emotional, physical condition.
Can we approve?
Yes.
She doesn't look like she just crawled out of bed this morning. She looks more put together and less victim. Slower than my desktop computer, Andrea. That's good, Andrea. Yeah, we both grab. Mm. I want to tell the DA, assistant DA, to brush out her hair. Those barrel calls
Did
don't
Ms.
look good.
Benefield that morning give you any indication that she was in pain?
Yes,
And did you refer to any particular area?
yes,
What?
her head.
Thank you.
Redirect.
No.
There's no redirects in this group.
Can this witness be released?
Yeah, I'm sorry, no, she's to remain under subpoena, she can be released at this time.
Ma'am, the rule of sequestration has been invoked by the attorneys. So that means that until you're released from your subpoena or until the jury is discharged, you're not to discuss your testimony in this case with anyone outside this courtroom, including the attorneys. You're not to talk with any other witnesses about your testimony. You're not to talk with any other witnesses about their testimony or the questions that were asked of them. And it's my understanding this may be online. You're prohibited
Yeah.
from watching anything that's going on within these four things.
Absolutely.
Thank you, ma'am.
Thank
Just
you.
leave the picture there.
I will do so. Thank you.
All right, state.
That's possible, case one.
State call Lieutenant Dan Dickerman. I knew he was caught in the line, so I just wanted to make sure he's here.
They're calling witnesses that are not on their list. FBI.
Hold on one second. You approach it.
Yeah, they're calling people that are not on their witness list. Daniel Dickerman. I am sorry, guys. I got to keep an eye out for Miss Jules' communication.
You solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I did. Hello, sir.
Yes, sir.
My name is Judge Ryder, presiding over the case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. It does adjust up, down, left, right, however you read it. You're speaking loud, clear voice, you should hear it.
Yes, sir.
Good morning.
Good morning.
Please state your name and spell your last name.
Daniel Dickerman, Dickerman.
Where do you work?
What a
The
name.
Manatee County Sheriff's Office
How long have you worked there?
for almost 29 years.
What is your current position?
I'm a lieutenant in road patrol.
And what was your position back in 2020?
I was the senior homicide investigator assigned to the Manatee Homicide Investigative Unit.
So Manatee County, say that again?
Manatee Homicide Investigative Unit, MHIU.
MHIU. Okay.
Yes.
So you were the senior investigator in that unit.
Yes.
And if you could just explain a little bit, what is that unit?
So that unit is a group of detectives formulated from all the agencies within the county, the sheriff's office, Braden Police Department, Palmetto Police Department, and all three beach agencies. We all respond out to all homicides that occur within the county, regardless of city jurisdiction, everything, so we can all work together and investigate that and determine if any criminality is a result of that homicide will need to come forward.
And just discuss a little bit how you work as a unit, and is that different than how a detective may work in a different part of the sheriff's office?
Yes, in the sheriff's office, most cases are assigned to a single detective. They go out, they do all the work, they write the report, they bring everything together in a normal, smaller case. In these cases, we determine what we call a lead detective. That lead detective then becomes, for all intents and purposes, the supervisor of the case. He makes assignments. We go out, all the other detectives, we do our respective assignments, we report back. The lead detective becomes a basic gathering point and a keeper of all the information to make sure the flow goes smoothly to one location and we're not duplicating efforts or stepping over each other's toes. And then he makes the ultimate decision once he has all the information.
And are you, as a unit, a part of any decision-making that happens within the unit or that happens in a case?
Yeah, we have meetings on every case
Okay.
to discuss the comings and goings and the happenings of the different case.
And so did you work in this unit, the MHIU, at the time that the shooting occurred?
I did.
On the date of the shooting, were you called, were you notified of the shooting?
I was.
And about what time was that
It
approximately?
was between 7:30 and 8 p.m.
Did you go to the scene?
I did.
And when I say the scene, where the shooting happened?
Yes, to the neighborhood of White Rock, I believe it was.
Was the defendant there?
Yes.
Where was she?
She was in the back seat of Deputy Burley's patrol vehicle.
Did you go into the house?
Not at that point. I did after the crime scene unit had already documented everything and made sure nothing could be contaminated, done their investigation inside. Then I went in briefly at the end.
Okay, and what did you see?
I saw some blood trail on the floor, a bullet strike in the wall of the bedroom from a projectile. And that's about it.
And were other members of your unit there at that scene?
Yes.
Were there other members of the unit at other scenes or other places?
Yes. Detectives were also sent to our main offices, criminal investigation division, which is where our interview rooms and our offices are located.
Okay. And from the beginning of when you arrived on scene, you knew that there was a self-defense element of this crime.
Sustained.
Did you know there was a self-defense element when you got there?
Object the leading.
I'll overrule on that.
Yes.
While you were at the scene, were you made aware that the defendant was going to be going to the station?
Yes.
Okay. Was the defendant's mother, Alicia Byers, there?
Yes.
Did you speak to her?
Yes.
And at some point, did she hand you a phone?
She did.
Okay. And did you know why she was handing you the phone?
Originally, no, but then
Okay.
I found out shortly after.
Who was on the phone?
A lawyer.
And did you speak to that lawyer?
Object.
Sustained.
So Mama called the
Did
lawyer.
you explain to Alicia Byers what was going on and where her daughter was going to go?
I did.
And ultimately, how many lawyers ended up at
Object. Relevance.
If you want to approach and explain the relevance.
Y'all. It's not unusual to have an attorney, but have multiple show up. That's unusual. My mini platoon. Spittoon. Those are so good, y'all. I don't want to stop eating them. I don't want to get myself sick. You okay, Diane?
At the time the defendant went to the station, was she under arrest?
No.
Was she ever arrested that night?
Object leading.
Sustained.
When was she arrested?
Sometime in November,
And the shooting happened?
in September.
And that seems to be a month or two delay. What do you know what delayed that?
But for the investigation to continue into the self-defense claim.
Did you go to the neighbor's house, John Sant?
I did go there briefly, yes.
Okay. And did you have any discussions with him or anyone?
I did not.
Okay. Was Child Protection Services on the scene?
Yes, they were called to the scene.
And just briefly, what is Child Protection Services?
Objection. Relevance. Consistent with the court's prior concern 403.
Overruled.
What is Child Protection Services?
At the time, it was a division of the sheriff's office.
At the time, it still is.
With, protecting the children from abuse, or make sure they're in good locations, or just make sure they're healthy.
So do you know why they were there?
Yeah.
Objection.
Sustained.
Did CPS try to speak to Alicia Byers?
Yes.
Were you present when
Yes.
Alicia Byers?
Yes.
Was Alicia Byers cooperative with them?
I wouldn't say fully cooperative. She did ultimately answer a vast majority of the questions, but not cooperative per se.
Okay. And was there anyone else present at the time when they were trying to speak to Alicia Byers?
Off and on, Barbara Russell was present.
Did you also assist in executing a search warrant?
Yes, I was on scene
And where was that search warrant? Was that at the house?
at the house.
Okay. Did you have any assignments for gathering evidence?
Yes.
And what evidence was that?
To originally look for video in the area of the park of the neighborhood.
And did you do that?
I did.
Were you able to obtain video?
I was.
And on that video, did you see what we believe to be Alicia Byers and the child at the park?
Yes, they were at the park.
Did you also obtain other types of videos?
Yeah, I also viewed ring video from the scene itself.
Objection, relevance.
What video?
Ring from the
Ring.
scene.
But overruled, I mean, you could say he viewed it.
And in viewing that, did you see any part of the incident that we're here about? Was it captured on the ring camera?
The shooting, no. The arrival of the U-Haul and the arrival of the deputies were on there.
Okay. I have no further questions. Thank you.
Thanks.
Good morning.
Why didn't you ask the mother about the CPS?
So through your testimony, among other things, the state proved this morning that there was a U-Haul truck there
Yes.
and that the deputies arrived
Yes.
and that there was a homicide.
Yes.
Okay. Now, you mentioned that often the practice is when you respond to a homicide, it takes some time to conduct an investigation to determine if there's criminality.
Absolutely.
Okay, so in other words, you don't come upon a homicide and determine as soon as you see a dead body, it's murder.
Correct.
Okay. If I wanted a job in your unit that you supervise and I felt all homicides are murders.
Objection.
Fair question, Your Honor.
Objection. Pre-trial ruling.
Sustained.
You mentioned that the arrest of Miss Benefield, well, let me start from, I think you told us she was in the back of the squad car.
Yes, sir.
She was in handcuffs.
Yes.
And this is a squad car with the doors that you can't open from the inside in the back, correct?
That's correct.
With a cage.
Yes.
So she's in the back of the squad car, in handcuffs behind her back,
Yes.
in a car with a cage, and you can't open the doors, but she wasn't under arrest.
No, she
Who
wasn't charged with
knows?
anything.
Okay. So I think you told us that the reason for her being arrested approximately 6 weeks later, I think, was so that the investigation could be conducted.
Correct.
Because
Not unusual.
you had to determine if there was criminality.
Correct.
Okay. Could have been a homicide that was self-defense.
Could have been. That was the claim.
That's the whole point of the investigation.
Absolutely.
And that kind of an investigation, understandably, takes time
It does.
and patience
Yes.
and professionalism
Yes.
and knowledge and experience.
Yes.
Do you know how old Lieutenant Alicia Byers is?
I don't.
Do you recall meeting her?
I do.
Approximately, give us your best shot.
I mean, I would guess in her 40s to 50s.
All right. Was she a young woman?
No.
She was pretty exhausted that day, wasn't she?
She appeared to be. There was a lot going on.
Yeah. Would it be a fair statement, Lieutenant? You seem like a pretty straight guy. Was she emotionally distraught?
Yes, there's a lot of emotions going on there. Yes.
In fact, her first thought upon coming back from the park with the daughter and seeing the
Objection.
cars was that
Hearsay.
her daughter was
Please
dead.
stop.
Hey, dude, you can't testify through
Unless you'd
questions.
like to make an argument for an exception, then you can approach.
Rest gesti?
Well, if you'd like to approach.
It's all right, Your Honor.
Jeez.
I think, Lieutenant, excuse me, you told us that you went into the residence after crime scene had completed their portion of the investigation.
Yes, sir.
And do you recall crime scene was there before or after EMS?
A crime scene comes after EMS. The sanctity of life always comes first.
All right. So EMS was there first, and you were there, so you know they dragged Mr. Benefield out of the home from
Yes.
the bedroom.
Yes.
So you
Dragged?
told us that crime scene was there to preserve the scene. Can we agree, Lieutenant, that what crime scene preserved was the scene following the EMS people not only working on him in that bedroom, but moving?
Yes. As always, that we preserve the scene after we attempt to save the life.
Okay. And so those crime scene photos show us, for example, what that scene looked like when crime scene took the photograph.
That is correct.
It doesn't show us what the scene looked like when EMS was running around doing what they do.
That's not possible. No, that's correct.
Okay. And that would have included the initial deputies on the scene as well.
That's
God bless
correct.
you. Give me just a moment, Your Honor.
Yes, sir.
You don't drag a body out. You remove the remains or the victim. That bothers me. And this guy knows he has a losing case and he's doing everything in his power to save something. He doesn't seem to be all that prepared to me. He just
Thank you, Lieutenant. Appreciate your candor.
Thank you, sir.
feels like he's just pulling it
Yeah.
out of his head without no plan.
Mr. Taylor,
No focus.
be released from
Yes,
your
sir.
subpoena. Sir, you were released from your subpoena. You're free to go.
Yes, sir. Thank you very much.
Space.
Can we approach?
This drives me crazy. Does he feel prepared to you, Diane? You don't know. You're not paying attention. I was like, he said, drag the body. You don't, that's not acceptable. You don't drag the body. Yeah, it doesn't. No. All right, baby. All right, baby. Get the door. Get the door. I'm like, hey, where's Toby? Oh. Now you know how I feel. Yeah. Do y'all remember the little puppy from last week? The puppy mom is here. And I said, where's the puppy? And she goes,
Members of the
oh,
jury,
at
we're
home.
gonna take
I'm
our
like,
morning break right now. So you can step back into the jury room. Please close your
With the
notes, leave them
puppy.
right where they are. Should be 10 or 15 minutes. Stretch your legs, get something to drink back there, use the facilities. Please don't begin discussions amongst yourself. You are free to still use your cell phones
Matthew.
to send me text messages, calls, anything like that. But please don't discuss the case outside of this group and don't do any research on the people, places, things, or legal topics we've heard anything about. Thank
I
you.
apologize. I had to get up and shut the door. My son opened it and didn't shut it. That. That. Oh my gosh. Okay.
All right, y'all can have a seat. We'll be on recess. Bless you, 10 minutes.
Okay, I'm ready. I may get a call. I may not. We'll see. I've got it ready. Got it geared up. Oh, I need to undo that. So I know she's calling. Let's see. Let's see. Either a call or text. She's on the phone. Man, let's see what she's got. Hey. Huh?
Where did the 5 go by the register?
I only sold 2. I don't know where the rest went. I only did the 2. That was all that I sold.
There was 3 up there.
I only sold the 2 you told me to.
Okay.
Sorry. Business. Go, Sensei. Go. Go, go, go. There's no substance to any of these questions. Case 1, you're correct. I'm like, really? It just, why not ask the mom? Any questions? Why not ask the mom? Yeah, stone-faced. Nope, nothing. Emotionless. Oh, ah! Question, Miss Diane. Would you be willing to interpret with me the debate? Presidential? Because I have some deaf people asking for interpretation of the debates. So you pick a person, I take a person. That's awesome. Whoop, 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 whoop. Hi, Tracy. My sis. How you feeling today, sis? The one thing that I've noticed about this trial on both sides is the lack of quality questions. It's like you have the mother up there. I could care less. I could care less what the mother feels or thinks about being there, but I would be asking questions. How often were you around the couple? How did they behave? Did your daughter ever call you with a complaint? All I see is woo-hoo. What is that? See message above. Is there one further above? What does woo-hoo mean? So I'm sitting here and I'm like, did you ever see them argue? Did you ever see them fight? Did you ever hear them? Did she ever call you in the middle of the night upset and crying? Did you ever see any bruises on her? Yes, Miss Diane. I know you're trying to work on the lighting. Did you ever see all of that? I guess Jules is on with our friend. I think she's on with our friend. I think that's where she is. I just feel that the questions are just so blah. Hold on. There are two women on the front row. No one is looking at the defendant. This is coming from Jules. I'm listening to her talk to RA. That's true. Yeah. Oh, God. I'm so sorry, Tracy. Good point. So she's not making much movement. Good. I'm listening. Oh, wow. Hold on. I'll tell everybody what's happening when Diane gets back. The mom left the bench crying. Oh, you're dark now. Can you see yourself, Diane? You're real dark. Okay, Miss Kevin. Oh my gosh, y'all. So I'm listening. I'm listening. I'm sorry. Okay, here's some skinny. I'm listening to Jules. Okay, we'll see if she calls us. She's hanging up. Okay. So here's well, let's see if she calls. And if she doesn't call, then I'll give you what I heard. Oh, she's heading back in. So she called RA first. Okay. All right. So here's what I heard. She said she was going to go back in. So here's the skinny that I heard. Maya's mom. I'm sorry. Sorry, Maya. That's no disrespect on you. Ashley's mom went back into the courtroom. Left the courtroom from the stand with tears because she was not released from her subpoena. And so she cannot sit with her daughter, sit behind her daughter. The mom cannot talk to her daughter about any of this. She's still under. That looks fine, Miss Diane. Hold on. Sorry about that, guys. Had an important call. So what's happening is and this is a good point, very good point, in that um, the um, the behavior of Ashley is very subdued, quiet. She's not really looking around. She's not moving a whole lot. There's no drama. It's very, very, very quiet. No reactions. That is something I noticed, that she doesn't have a whole lot of reactions to anything. In that sense, she kind of reminds me of Hannah Gutierrez Reed, or Hannah Gutierrez. But it really upset the mom that she's still under subpoena. Really upset mom. So, yeah. So Jules, of course, called RA first. That's her priority, but she will get with us either via text this morning and then probably at lunchtime. So I will probably hold on through lunch, but I'll break the stream. So as soon as this is over, I'm going to shut this stream, but then I'm going to feed it back up and get the next stream. So y'all can just hop on over. You don't have to worry about searching. It'll be right up. Okay. So what I think I'm going to do is, while they're still on a quick break, I'm going to go take a little ladies break, and I'll be right back.
Folks, I need the audience to sit down and take your seats, please. We need to get started. All right, welcome back, members of the jury. Hopefully no one started deliberations amongst yourselves, talk with anybody outside the jury about the case, or did any research on the people, places, things, or legal topics we've heard anything about. No? All right. State, call your next witness.
State called Stephanie Murphy.
Yes.
Was there an objection? Just a sidebar?
You solemnly swear or affirm
Ooh, beautiful woman. Wow. Love the color.
Hello, ma'am.
Good morning, Judge.
My name is Judge White. I'm going to be presiding over the case. Get yourself about
Classy.
12 to 15 inches from the microphone. It does adjust up, down, left, right. Just make yourself comfortable. If you speak directly into the microphone with a loud, clear voice, we'll hear everything.
Thank you.
Thank you.
Good morning.
Good morning.
Please state your name.
Stephanie Murphy.
How do you spell first and last name?
Stephanie is Stephanie. Murphy is Murphy.
And what is your profession?
I'm an attorney.
How long
Ah,
have you been an attorney?
This is my 23rd year as an attorney and actually in the Sarasota Bradenton area.
And are you with a firm, sole practitioner? What do you do?
My husband and I have our own firm, and I've had that firm for 16 and a half, 17 years. Before that, I was at a larger firm in Sarasota.
And what is your topic of law that you practice?
I practice family law, which is generally comprised of divorce, custody cases, or what used to be called custody cases, and adoption cases.
I want to ask you about Doug Benefield. Did he hire you?
He did.
And approximately when did he hire you?
He hired me in March 2018. He came for a first consultation on the 13th. He hired me on the 14th of March 2018.
And what was the purpose of your duties to begin with?
Initially, the purpose of hiring me was to draft a letter to Ashley Benefield, who was pregnant with their child at the time, which I did. I drafted a letter and sent it the day after I was retained. But the purpose of that letter was actually just to initiate.
Relevance. She stated that she sent the letter, that she was retained to send the letter. Now going to explain something.
Okay.
ooh,
was
look
the
at the look
purpose
on
of
that
the letter?
face.
The purpose of the letter was to open the door for discussion about Doug's participation in the upcoming birth of their child, but also to advise that if she did not feel comfortable with him being present at the birth, he was respecting her need for space.
And when did you send that letter?
I sent that letter on March 15th at 9:59 in the morning by email to Ms. Benefield.
And did you receive a response to that letter?
I did not receive a response directly from Ms. Benefield. She checked herself into Tampa General the next day to start induction.
Sustained.
So when was the child born?
Well, the child was born early. She was born on March 19th, I believe, is when she was finally born.
And you said early. How many weeks early was that?
Well, the child was originally scheduled, or her due date was April 8th. So I think
Sustained.
So you said you never received a response
not from Ms. Benefield.
from Ms. Benefield about the letter.
Correct.
And to your knowledge, did Doug ever receive a response?
To
that
my
letter?
knowledge, he did not receive any response from Ms. Benefield or anyone on her behalf.
And I think you might have said this, but the child was born on what day?
She was born on the 19th of March.
And at the time the child was born, did you or Doug know that the child was born?
No, gosh, we didn't know for a good 5 or 6 weeks after she was born.
And how did you find out that the child was born?
I actually found out because I had been monitoring the docket for Manatee County court system, just because there had been no response. And so on May 6th, I saw that Ms. Benefield had filed a petition for protection against domestic violence on, I think it was April 23rd. So about 2 weeks prior to me finding out, she had filed the petition. And in that filing, there was, she identified the birth date of the child, as well as I think the child's name, which is the first time we learned about that too.
And you said she filed a petition for, what did you call it?
It's a petition for protection against domestic violence. So it's an injunction. A lot of people refer to it as a restraining order, but it wasn't granted as an injunction at the time.
So when, just for knowledge of people that may not know, when someone does a request for an injunction, what is sort of the procedure that it needs to go through?
A person who files a petition for an injunction, they file it at the courthouse in the clerk's office, and then that gets sent up to the judge, usually a family law judge who's just in charge of injunctions that day. And then the judge has three options, I believe. One is just to deny it completely. The second option is to grant a temporary injunction, but then there's a follow-up or a return hearing.
I'll overrule.
And then the third option is what happened in this particular case, is that the judge denied the petition as a temporary injunction. So there wasn't enough evidence in the petition to warrant a temporary injunction, but a hearing was set to review it.
Okay. And when was that hearing set approximately, to your knowledge?
I believe it was originally set for May 8th, but Ms. Benefield made a request to continue that hearing.
Okay, so it was then continued?
It was.
Before the hearing actually happened, did you file any documents on Doug's behalf?
I did. So, well, of course, I filed a notice of appearance in that injunction case. And then we started an entirely separate case. So I filed on Doug's behalf a petition for a parenting plan unconnected with divorce. So he wanted to establish a parenting plan so that he had really time sharing and decision making for his daughter, because he had none of that up to that point because she was withholding all that information.
And some of the lingo may be familiar to us, but so time sharing, what is that?
I'm sorry. So time sharing is what lay people and a lot of people used to generally call visitation. So it used to have custody, parent had custody, and then another parent had visitation. That was changed, and now in Florida at least, and especially in our circuit, we have parenting plans, which is a comprehensive agreement or an order by the court that lays out all the details of parenting as a not intact family. So the major components are decision making and time sharing schedule. So how often the child spends with each parent.
And you said not connected with a divorce proceeding?
Right.
So I would assume that means it can either be with a divorce proceeding or without.
It can be, and of course it can be also in a paternity case. So parents don't have to be married. But in this case, because they were married, Doug was not initially pursuing a divorce because he hadn't had any contact with Ms. Benefield for a while. His initial...
Sustain.
Okay. So initially it was not connected with divorce.
Right. His priority was his daughter.
And you mentioned the injunction case and then your motions. Were they two different case numbers?
They were two different case numbers. So the injunction case number was 2018 DR 1823. And then the new case that I filed for Doug was 2018 DR 2318. Now they're companion cases though, so they might be separate cases, but they travel together as companion cases and they're assigned to the same judge through this unified family court program.
So when the hearing was set and ultimately heard, were both of those case numbers heard?
Both of the case numbers were heard, but it wasn't our first pleading wasn't the same pleading that was heard at the time of the injunction.
It's narrative, non-responsive to the question.
Sustain.
So what generally were the allegations in the injunction petition?
Generally, Ms. Benefield was alleging that Doug had been violent toward her. She alleged that he, I think, had hit the dog, fired a gun into the ceiling. The biggest allegation was that he was poisoning her and their child in utero with heavy metals.
Okay. When was this hearing finally held?
The hearing was held in two parts, actually. It was July 30th, and then the second part was September 17th.
Not responsive to the question.
Overrule.
And that was the year 2018, correct?
Yes, it was.
Okay. And what judge was this in front of?
It was in front of Diana Moreland.
And you said it was held on 2 days. Why was it held on 2 different days?
It took a very long time. So
Okay.
we had, both sides had experts, toxicologists, and we had a number of other witnesses appearing. We had,
Objection, not responsive to the question.
Overruled.
there were also people from the child protective team testifying. And so it just, there were too many hours. And so we couldn't squeeze it all into one day.
Okay. And ultimately, at the end of this, did Judge Moreland make a decision?
At the end of that, she did. There
I'm
were other
sorry.
decisions along the way, but ultimately she made a decision on the two matters that were set as the companion cases.
And what I meant was on the second hearing day, did she make a decision?
Yes, she
Okay.
did, September 17th.
And what was that decision?
There were two parts because, there was two cases.
Objection, Your Honor, just final decision.
For the prior motion,
Yes.
overruled.
Okay, go ahead.
Thank you. For the injunction, she made a lot of rulings and a lot of findings about lack of evidence and then
But
denied
we don't
the
want to.
petition.
We don't want to talk about
Oh.
what went into that. We just want to know what her
Gotcha.
ruling was.
Okay, she denied the injunction. So
Okay.
that was the first part.
Okay. And then the second part.
The second part was on the parenting plan case, or the time sharing case. And so in that, she entered a ruling for a time sharing schedule. That would be an introduction schedule because Doug at that point had never met his daughter, and that would increase over time on a temporary basis. And then she entered a ruling that he would have ultimate decision-making authority over the child's medical needs and otherwise shared decision-making.
Overruled.
And otherwise, I'm sorry.
Otherwise shared parental responsibility, which is joint decision-making.
Okay. And as of that day, was Judge Moreland's ruling timed? Like, was it immediate? Was it in the future? For the time sharing? of the
It was
child?
immediate. Well, not that day, but she said the first day, and it was just a couple of days later, the 21st, which is when Doug was supposed to meet his daughter for the first time.
Okay. And this time that Doug met his daughter for the first time, were you present?
I was, yes.
And where did this happen?
It happened at Manatee County Sheriff's Department on, I think it's 301.
Did you arrive together or separate with Doug?
Oh, we arrived separately. When I got there, Doug was already there.
And how old approximately was the baby at the time?
I think she was around 6 months old. She was born in March, and this was then the 21st of September. It's about 6 months.
And can you explain how that interaction went? Did you observe it, first of all?
I did.
Okay, and
So
how did
when
it-
I arrived, I got into Doug's truck and we just waited because we were there early. And then he saw Ashley arrive with the baby. And so he pulled the truck closer, and then we both got out of the car and started walking toward Ashley. And then it was just an odd kind of interaction, actually. She turned to me with this nasty look on her face and said to Doug,
Objection.
I'll sustain as to the characterization.
she turned to Doug and said, "Are you dating her?" And so obviously we both said, "Well, of course not, no." And then I hung back, and Doug then was standing there, and Ashley approached him with Emerson, and they started talking. Eventually she let him hold the baby, and they just kept talking for a few minutes. Then I was advised that they were going to be leaving together, strangely, that Ashley was going to be going with them for the time sharing.
Was this a surprise to you?
Absolutely. We had just been in knockdown, drag out litigation for months with just horrendous allegations that were unfounded. And yet she said, "I want to go with you." And he said, "Okay."
Objection to the characterization of the allegations being unfounded and continued editorializing by this witness.
That is weird.
Sustained.
That is weird. Very much so. Very strange. I love this woman. She's a good witness. And she is beautiful. Again? Yes. Very put together.
So when
I one day want to
they
look like
told
her.
you they were going together, what was your response?
I pulled Doug aside and I cautioned him about going with her. I advised, I'm his attorney, and so I did advise him. I said, this isn't a good idea. She's trying to set you up for something. Don't do this. And he said, I understand. I'm going to go ahead and do it anyway. And so I stayed and observed as Ashley strapped the car seat into the back of the truck, and she got in the truck with Doug, and then they left together for his first time sharing with his baby.
Okay.
Their baby.
So after this first time sharing, did this seem to start a time of peace, so to speak?
It was a time of peace. I actually before the 26th, but on the 26th, Doug and Ashley both signed a stipulation that I had drafted at Doug's request, which expanded the time sharing that Judge Moreland had ordered at the hearing on the 17th. So within a week, they had already agreed that he was going to have even more time sharing than Judge Moreland had said.
Okay.
And so that was filed in the court file. It took away the restriction of meeting at the sheriff's office if they chose.
Non-responsive.
Overruled.
So yes, that was the beginning of a time of peace that extended for quite a period of time.
And during this time, well, how long did that last, the peace?
It lasted, to my knowledge, about 11 months.
Okay. And during this 11 months, did you see Doug and Ashley?
I saw them in magazines. Actually, they were attending gala events together, and so they were kind of the
speculative and hearsay.
Overruled.
so other than seeing them together at the sheriff's office, I didn't personally observe them out in public, but I did. Like I said, I saw them in various forms of media. They're quite the couple.
Okay. And you said this peace lasted about 11 months. What broke this peace to your knowledge?
Well, it was my understanding from Doug that they were getting ready to move in.
Hearsay.
Let's not talk about what happened with what Doug said was supposed to happen. But during this time, did Ashley stop speaking to him?
I'm sorry, I didn't hear the question.
During this time, did Ashley stop speaking to Doug?
Objection. I'll let you know it calls for hearsay.
Effect on the listener.
Overruled.
Thank you. They continuously spoke to one another for 11 months until August 16th of 2019.
Objection. I thought that was yes or no. Objection, non-responsive.
Sustained.
So around this time, you said November 16th?
August 16th
August 16th.
of 2019.
Okay. What happened at this time?
Doug was supposed to be moving in with Ashley and her mother, Alicia. He had moved all of his things in.
And we're not going to talk about the specifics of that.
Sir, counsel, I'm sorry to interrupt. I request the instruction from the court about
Can we not do speaking objections?
Do you need to approach?
Wow. I like her a lot. Oh, my dog is all like, what's going on, baby girl? Why are you growling over there? When my dog is content, she'll go, She's my girl. Okay. Really am liking this witness. Of course, she's a lawyer. I don't think I've ever seen one other attorney ever get on the stand and testify, but it's not their favorite thing to do, I'm sure. But definitely best witness so far. Definitely the best witness so far. Really like her. I'm getting a better description of who Doug was and the timeline. It's a little more clear to me, which I'm happy to see. It has not been a very clear case as far as Who, what, when, where, how, and why. You okay, Diane? I can't hear you. Hold on. Let me get you on. Okay.
Still not liking my lighting that I can
We'll work
see.
on it.
It's bad. It's really bad.
I know. We'll work on it.
I sent you a picture.
Okay. I'll look. Where'd you
Messenger.
send it?
Messenger.
All right. Let me mute. We're going to start. Oh, it's not a ring light. It's just like a lamp. Point it up to the ceiling, straight up to the ceiling. Well, can you angle it? It's this. Can you make it that? Hold on.
In
Say
that
that again.
picture.
Huh?
It was that in that picture. So I just did
Well,
it
it looks like
straight
I
up.
want it parallel to the ceiling.
I just did that. It was it was it was angled in the picture, and then I did it just straight up.
This is one of those
Okay,
situations
I'm
that's
gonna
take
buy
us
you a
2
light.
minutes, So I'm gonna excuse you back to the jury room. Again, please don't.
Start of the month.
Deliberations amongst yourselves. Please don't contact or speak with anyone outside of the jury about this case. Don't do any research on the people.
We want a lunch?
legal
A
topics
break already?
Or anything about, but certainly you can use your phones and everything else to communicate. Thank you.
Only 9:30.
Go place.
So
Go place.
short break.
We'll see if we get a call from Miss
Once
Jules.
the jury's out, you can all have a seat. Just where at this point, I'm going to excuse you from the courtroom so we can have our hearing. Ma'am, the rule of sequestration has been invoked. You're not to discuss your testimony or the questions.
He knows what that is.
Including the attorneys, any other witnesses, any third parties. You're not to talk with other witnesses about questions they were asked or testimony they provided. And it's my understanding this may be on the internet somehow. So you're not supposed to watch anything at all that's happening within these 4 walls.
Okay,
Thank you.
She's just so elegant. She reminds me
Dresses.
Melania Trump. The elegance.
Mhm.
I'm not talking the
Witnesses
person
out of the courtroom.
togetherness. Jules, what you? Oh, that's not Jules.
Do you have,
Judge, I don't have a specific instruction. We may need to craft one, but what I'm looking for, so the court knows, is an instruction to the jurors that these hearsay statements that have been repeated by the witness thus far, and for purposes of the remainder of the testimony, the other statements she will undoubtedly try to get out, are not being offered for the truth of the matter, but rather being offered for whatever reason that the court wants to ascribe to provide the context of a narrative in response to the question.
so as I said, go ahead, do you want to be heard?
No.
So as I said, I'm not aware of a standard jury instruction in the 2.1 to whatever it is, 2.8 range or 2.9 range that does that very thing. So I want to give the parties the opportunity with the jury not present to look and see if there is a standard jury instruction.
I don't think.
I can give it. Like I said, I drafted one for a prior homicide trial where there were a number of statements that were admitted by me, by the decedent, where there were objections, just like we're having now, numerous objections to hearsay. But obviously, none of them were being offered by the state for the truth of the matter asserted. That's what was argued, and I made that finding. So in order to have just a blanket instruction, I crafted the following, and the parties ratified it. So I gave it specific to the decedent's statements in that case to, it was either an attorney or some sort of financial planner about some final wishes. And here's what it says. You are about to hear statements made by declarant, and I put the name in. These statements are relevant only to explain the reaction and responses that they elicit. That is, the effect those statements had on a reader or a listener, because there was also a letter that was involved. You are not to consider the statements by declarant's name as true, but only to establish the context of readers or listeners' actions, reactions, and responses.
That'll be fine.
Except for that you are about to hear me, because they've already heard some, so.
So the court want to substitute, you've already heard and may continue to hear. And by suggesting that, I'm not suggesting that I agree to the further admission of hearsay or interpretation that's not directly responsive to the question.
So reserving on other objections. And certainly there may be objections you have as we go where you think that they are not being offered for the effect on the listener and that it's hearsay without exception. So those still may come up. All right, so when we bring the jury back in, you want me to give that instruction?
Please.
You have heard and may continue to hear statements made by Doug Benefield to Stephanie Murphy. These statements are relevant only to explain the reactions and responses that they elicit. That is, the effect those statements had on Ms. Murphy.
If I may,
Yes.
I would suggest that it just name Stephanie Murphy, not Doug Benefield, because I think in her testimony it's been broader than that. So I think by identifying the instruction as it relates to this witness, the jurors will consider the testimony appropriate.
All right, so let me go through this again because I have declarant and recipient, reader or listener. So you have to tell me where you're talking about.
Sure.
You are about to hear statements made by Doug Benefield. These statements are relevant only to explain the reactions and responses that they elicited. That is, the effect those statements had on Ms. Murphy. You are not to consider the statements made by Doug Benefield as true, but only to establish the context of Stephanie Murphy's actions, reactions, and responses.
Okay, so I would, here's my concern. For example, Ms. Murphy also testified about Judge Moreland and about a couple of the medical records and things like that. And I would prefer, and I think the fairest interpretation would be, ladies and gentlemen, Stephanie Murphy has previously said and may continue to refer to out-of-court statements. You are instructed that these statements, if and when made, are not, you should not consider them for the truth of the matter asserted, but rather for context as it relates to Stephanie Murphy's testimony. That's how I think appropriately it should read.
Response?
Judge, I don't really, I think these things that he's talking about were objected to and they were stopped. So I don't know that it's better to highlight it anyway, but I don't know if adding names in of people to fit this, Doug, statements of Doug Benefield, this person, this person, I don't know that that would be effective to the jury. So I'm a little confused about how to handle it.
All right. Any final thoughts?
No.
All right. I'm open to giving limiting instructions, curative instructions that are suggested by the parties. However, the most recent one proposed by the defense, I don't think is legally accurate. It would be telling the jury to disregard testimony and evidence that's already been presented. I thought the request from the defense, because the objection came specific to Doug Benefield was supposed to move in with the defendant, and that's where we stopped. So it was my understanding that the instruction that was requested was specific to any statements made by Doug Benefield to Stephanie Murphy, that those are only relevant to explain the subsequent actions and effect that those statements had on Miss Murphy, and telling the jury not to consider the statements by Doug Benefield as true, but only to establish the context of Miss Murphy's subsequent actions, reactions, and responses. I don't think the limiting instruction proposed by the defense is the correct one to give. So I'm open to considering language that we can talk about some more, but no, the one you just said I don't think is appropriate.
All right, well, the message that we're trying to give the jurors is that when this witness makes hearsay statements, that the jurors should not necessarily receive that information as true, that it is being offered rather not for the truth, but to show the effect that it had on this witness. After all, that's what this witness is testifying to. She did not limit it just to what Doug told her, Judge. She's referred several times to what she heard from Ashley. She's referred to medical records and to allegations. She's also referred to Judge Moreland's decisions. She's expanded upon them. She's incorporated hearsay into her testimony. This was why I approached the bench before she took the stand. So I anticipated this. That's the way she's conducted herself in the deposition and in all of her prior statements. So what I want, respectfully, Your Honor, on behalf of Ms. Benefield, what I want the jurors to understand is that as it relates to Ms. Murphy's characterizations based on hearsay, that they should not receive it for the truth of the matter asserted. Rather, they should receive it to show the impact that it had on Ms. Murphy.
Response.
Judge, first of all, anything that Ms. Benefield said is not hearsay, so it does not qualify under any of this analysis. I do not believe she said anything about medical records. I may be wrong. She did start to mention that she checked herself into the hospital. There was an objection and she stopped speaking. So I would agree that that your idea is correct and that should be the instruction.
Final thoughts.
So
I agree. This is strange.
everything that a defendant says is not necessarily admissible. It's not necessarily relevant. It's not necessarily an admission. For example, Judge, if during the course of all of this, Ms. Benefield may have stated how much she loved this routine of a mouse named Topo Gigio, I think we could agree that would have no relevance. And if this witness wanted to get up and talk about that merely because that is something that Ashley Benefield repeated, that wouldn't make it acceptable. So I vehemently disagree with Ms. O'Donnell's statement that anything the defendant says is admissible. And I'm concerned about the editorializing by Ms. Murphy being interpreted by the jury as truth, as unvarnished and documented conclusions. And so I would like the jurors to know basically the definition of hearsay. I would like the court to instruct them that it's not being offered for the truth of the matter asserted. It's an exception, and it can be considered to show how this witness reacted to it. That way, Judge White, it expands the parameters wide enough that the instruction would include hearsay from any source that Ms. Murphy refers to, whether it be Ms. Benefield, whether it be Doug Benefield, whether it be the hospital records or Judge Moore.
All right, thank you both very much. At this point, I don't plan on giving any sort of cautionary or limiting instruction. I heard the parties agree on language. It doesn't sound like the language I've suggested is acceptable to both sides. So at that point, we'll just continue with the question, objection, ruling. Specifically as to the request regarding editorializing and characterizing, I'm going to sustain on those grounds. There's been, I think my information in front of me is that Ms. Murphy is a fact witness. The request that I give the definition of hearsay to the jury is denied. As we all know, the determination of legal matters, including whether a statement is hearsay or not, or any sort of evidence is hearsay, that's a judicial matter, not a legal. It's a legal question, not a factual question for the jury. Those are my decisions. I'll note that it is already factored into a court's ruling if a statement is offered, if an out-of-court statement is offered to prove the truth of the matter asserted in the statement, it is hearsay. The issue then becomes, is there a recognized exception to that statement or to that hearsay? And is it relevant and material to the case? That's how I'll continue to make my decisions, subject to the objections and the arguments that are made. Are we ready to bring the jury back in?
I just have one scheduling question, if it's okay with your honor. We have, after Ms. Murphy, we have two law enforcement officers here. And then our next witnesses are Dr. Broder and Dr. Quintal. Do you feel like I'm safe in telling them they could come after lunch? That was when they originally scheduled, but they have patients and they're asking if they need to cancel to come early.
I have no idea how long these next, I don't know how long Ms. Murphy is going to take. I don't know how long the next two witnesses are going to take.
Well,
I have no idea.
I guess the question is, Judge, if we end at 11:30 or 11:40, are you going to want to take a lunch, or do I need to have Dr. Broder here? Because he's in with patients right now, so I need to be able to tell him. We originally thought he was after lunch.
You mean with Ms. Murphy?
We have Ms. Murphy and then two other witnesses we plan to do before lunch. I just want to know if I'm safe to tell the doctors they can come after lunch so they don't cancel patients.
My habit would be if we finish with witnesses around 11:45, unless the very next witness was both sides agreed it's going to be just 5 minutes, I would probably take a lunch break at that point.
Thank you. I asked it poorly. That's my question. I just want to be safe in releasing them so that, Your Honor, so we can keep them. Or not releasing them, putting them after lunch. 1:30? Should I tell them 1:30?
It depends on when we finish this morning.
I'll just tell them it's after lunch for now. Thank you, Judge.
Are you ready to bring the jury back in?
Yes.
Vince? All right, let's bring Ms. Murphy in first.
That was interesting. Wow. Defense lost on that one. Ooh. Hi, Haley. Hi, everybody. Thanks for joining. I have somebody who will be here in a few seconds. So if I drop off screen, I'm still listening. Please keep mods. Just keep an eye.
Ms. Murphy, have a seat as you're settling in. Did you discuss your testimony with anyone else outside of this room?
No.
Did anybody try to approach you and discuss anything about this case?
No.
Did you watch anything or any of the proceedings?
No.
All right, ma'am, while you were outside, I did sustain 2 objections that were raised by the defense. And that is some of your testimony.
That dress is
editorial
gorgeous.
rather than factual, and has been
Looks good on her.
characterizations of observations as opposed to observations.
Okay,
So just FYI, I did sustain those 2 objections.
okay,
Otherwise, we're just going to keep having questions and answers. I'll rule on objections as we go.
great, thank
All right.
you.
We'll bring the jury in.
She's like, I'm a lawyer. I know these things. Thank you. Jules changed shirts. No, she took off a shirt. She's now in white. I was looking for the black. Now she's got white. She took her sweater off. Courtrooms are often cold. Really cold.
All right, you all can have a seat. Welcome back, everybody. Did anybody begin discussions amongst yourselves? Talk with anybody outside the jury about the case, or do any research on the people?
Oh, excuse me.
Legal topics we've heard anything about? Everybody says no. All right, you may resume your question.
And I
Jules has
believe as we
gorgeous
left
hair.
off, Ashley and Doug were not speaking to each other. Pretty much not speaking to each other.
Right, beginning on August 16th, 2019, they were not speaking to each other.
Okay. And as a result of that, did you ultimately file anything on Doug's behalf?
I ultimately did, yes.
Okay. And what was that?
We filed gosh, let me think back, it was so many years ago now. A series of things, but one of the first things that we filed was an amended petition for divorce. And so it was actually a motion for leave to amend with the amended petition attached to it, which is the procedure.
So that ultimately means it was not seeking divorce before, but now the petition is.
Yes, that's correct. And still the parenting plan with some additional allegations, but that's what the main first pleading was.
Okay. And at some point after this was filed, did you get information that there had been complaints filed against Doug Benefield?
Yes, I did. So that amended petition was filed, I think, November 6th or 5th of 2019. And then within a month, I learned that there was a series of complaints filed with.
Also stand.
Ultimately, these complaints that were filed against Mr. Benefield, were they documented or filed in any way in your casework, in your cases?
Relevance.
I'll overrule.
So of course, we didn't attach them as exhibits to our next pleading, but we did file an amendment.
Editorialized.
Sustained. That would ask for a yes or a no.
Okay.
Can you repeat the question for me?
Those complaints, did they make their way, the information at least, into your filings in your cases?
Yes.
Okay. At some point, did Ashley file an injunction request based on these allegations?
Yes.
Okay. And around this time, was there a psychological evaluation ordered with Dr. Broder?
It was not ordered by the court. There was a psychological evaluation that was put into place through, I believe, the Child Protective Team.
Editorialized. How many times?
So an evaluation was recommended.
I sustained it.
I requested instruction from the court. Jurors to disregard the last answer.
Members of the jury, I have sustained an objection. When we had our initial instructions, the preliminary instructions
Okay,
on Monday
guys,
morning,
my guest
I
is
want to
here.
remind
I
you
will
of
be
those very
listening.
important
I'll be right
instructions.
back.
If an objection is made, you are not to guess or speculate as to why it was made. Likewise, you are not to guess or assume or speculate what the answer might have been had the objection not been sustained and the witness had been allowed to answer. So you're to disregard those last answers.
As part of this process with,
Hold on. Sufficient.
I'm sorry.
Thank you. Yes, sir.
Go
Sorry.
ahead.
As part of the process of these cases in court, did Ashley and Doug Benefield, to your knowledge, see a Dr. Broder
Yes, they did.
for a psychological evaluation?
Yes.
Do you know when this petition for injunction filed by Ashley was set for a hearing?
I don't remember the date that it was initially set because she filed a motion to continue.
Objection,
Basis.
editorializing, not responsive to the question.
Ooh.
Go ahead.
It was continued several times after she filed a motion for mediation, and then eventually it was scheduled to occur. I believe it was September 30th of 2020.
So you said it was continued several times because of a mediation. So just what is a mediation and what is that? How does that play in?
Okay, so mediation is a settlement conference that takes place. It generally involves the parties as well as their attorneys, and then a neutral person who's generally a certified family court mediator. And so what generally happens is a mediator goes back and forth between each side to try to work out an agreement. And in this case, it was ordered by Judge Moreland in response to Ms. Benefield's motion.
To do the mediation.
Correct.
Okay. And did you participate in the mediation?
I did, of course.
And also Doug and Ashley Benefield.
Yes.
And as a result of that, did some of the focus of the hearing coming up change?
In anticipation of the mediation, yes, the focus of the upcoming hearing on the 30th changed.
Okay. And in what way did that change?
Earlier in September, I think on the 17th, Doug and Ashley signed a joint motion to release the psychological evaluation reports in the divorce case, in the 2018 DR 2318 case. Because in that situation, the psychological evaluations had not been ordered by Judge Moreland. They were put into place through.
Objection, not responsive, editorializing.
I'll sustain on the narrative.
So they did a joint motion to release the psychological evaluation.
Yes.
And is that fairly typical? It's needed in this realm to get that result released to the parties.
Oh, of course.
Objection, relevance, it's what's taken place in this case.
Ooh.
A judge would not just release, is not
Good
able to.
question.
Oh, I'm sorry, Judge. I apologize.
A judge doesn't release that report unless.
The judge orders that it can be released.
Okay. And Doug and Ashley did a joint motion for that to happen.
They did.
And to your knowledge, what was their path forward from that point?
The path that went into place was they were reconciling and moving to
Object,
Maryland.
Speculation as to what the path forward was.
Ooh.
And so when we were leading up to the week that he was killed, it was agreed upon that they were going to result in an impasse of the mediation because they were reconciling. And then the hearing on the 30th, the week after, was only going to be to release the psychological evaluation report.
Okay.
And they were going to pursue the move to Maryland.
Okay. So ultimately, the only thing that was supposed to happen at this hearing on September 30th was the release of the psychological event.
That was it.
That was it. Okay. And do you recall what day of the week that was, September 30th?
I believe it was Wednesday. So the mediation was a Thursday prior to the killing. And then the hearing was supposed to be Wednesday, the 30th.
Okay. And what day was Doug killed?
Sunday night.
And that would be the 27th?
Yes.
And who was the judge going to be at this hearing on the 30th?
It was still Diane Moreland. She was still a judge on the case.
And at all times that you dealt with Doug, did he ever seem to you overly angry or aggressive about things?
No, I thought Doug was never angry. He was very mellow and matter of fact. That it was a point of contention between us, actually.
Okay. I have no further questions. Thank you.
Thank you.
Cross.
Yes. Good morning, Ms. Murphy.
Good morning, Mr. Taylor.
We've met on a few occasions, have we not?
Yes, we have.
And we meet again this morning.
It's lovely to see you.
So your specialty is family court,
Family law, yes.
and you've been practicing family law, I think you've told us 23 years. You have your own firm, you and your husband.
Yes.
And in that capacity in family law, correct me if I'm wrong, but when you litigate matters in family court, excuse me, there are rules and procedure that apply to family court, are there not?
In all courts, and including family court, yes.
Okay, such as the rules of evidence,
Yes.
the rules of procedure, family court procedure,
Yes.
and ethical obligations as well.
That's correct.
Those always govern your behavior with respect to the tribunal, the court, correct?
All of our behavior, yes, that's correct.
Are you familiar with Florida bar rules of professional conduct?
Relevance, Judge?
I'll overrule. I don't know where this is going, so I'll overrule for a moment.
Thank you.
I'm-
Are you
I'm familiar.
Yeah, Rule 4-3.3, candor toward the tribunal.
I'm familiar with that rule.
All right. You're familiar with that rule's obligation of a duty to disclose false evidence.
I don't have the rule in front of me, so if you want me to read and see if that's exactly in the rule, I can certainly take a look at it. I'm generally familiar with the obligation to provide candor to the court.
Yes, and to disclose if evidence is inaccurate. I think
Yes,
we can
exactly.
agree on that,
Of
correct?
course.
That would include, would it not, a failure to correct a materially false statement of fact?
Yes, I'm aware that that exists, but I don't see how that could apply to my case with Doug.
All right, well, let's see. I want to ask you about a sequence of events now relating to the litigation that you mentioned to us between Doug Benefield and Ashley Benefield.
Was this the injunction you're referring to or the divorce case?
I'll be very specific in my questions, if you'll be patient for a moment.
Of course.
Ashley Benefield files her domestic violence petition on April 23rd of 2018. Is that correct?
I believe that date is correct, yes.
Just so there's no mistake. She then, correct me if I'm wrong, because you seem to have the dates mastered. Ms. Benefield then files a petition for divorce and temporary TPR on May 31st of 2018.
I don't remember the date that she filed those, but she filed, those would be, I think, separate things. And so in response to the petition for parenting plan unconnected with divorce that I filed on Doug's behalf, She filed an answer and a counter petition seeking divorce.
So your answer for purposes of my question was you don't recall the date.
Yes, that's correct.
Okay.
And it wasn't that she
May I
just.
approach the witness?
Yes.
See if this
Yeah, I read it.
refreshes your recollection as to the date.
I need to get my reading glasses, Mr. Tate.
While you're looking at it, when I refer to the initials TPR, what does that stand for?
Termination of parental rights.
Okay.
Yes, thank you for the reminder. You're right. This is the 31st of May. And she did file a separate case. I had forgotten that.
Well, the question pending was, does that refresh your recollection as to the date?
As to the date, yes. The
Yes.
contents, no.
Was I correct in my statement to you that the date was May 31st, 2018?
Yes.
Now, would you take a look, if you need to refresh your recollection, as to count 2, specifically paragraph 5? Ms. Benefield makes some allegations there, does she not?
She does.
All right. On June 19th of 18, you file Mr. Benefield's answer.
I don't remember that.
May I approach?
Yes.
Let's see if this refreshes your recollection.
Thank you.
Is the date June 19th, 2018?
Yes, that's correct.
All right. And that's your answer, is it not?
This is Doug's answer that I drafted and
Okay.
filed on his behalf.
That
Yes.
you drafted and filed on his
Yes.
behalf.
Correct.
And in response to paragraph 5 of Ms. Benefield's petition, you deny it, do you not?
Objection relevance, Judge?
I think,
I'll overrule on those
yeah,
grounds.
thank you, Judge. Ms. Murphy, my question was, if you would look at paragraph 5, do you enter a denial?
I'm sorry, it's number 5 is 7 pages long. So I was just checking to see if that was correct.
Well,
Yes,
your answer.
we denied these allegations that
Okay.
he committed those acts during pregnancy.
Now, as part of that action, your client, Doug Benefield, submits to a deposition 27 days later on July 17th, 2018, does he not?
I don't remember that exact date, but he did submit to a deposition around that time frame.
Okay, and in that deposition,
Objection,
while,
pretrial motion.
Sustained.
Your Honor, she opened the door. She's already talked about,
Maybe
Would you like
approach,
to
please.
approach?
yes.
Hey, y'all, I'm here. I just had a dear sweet friend hop in and I've got a secret we'll share later. But I'm still listening. Thank you so much for being here, Miss Kevin. Thank you for coming back. Yay! Yay! But I am listening. We are going to have a chat in a little bit, but I'll be right back. Okay, guys? Thanks for hanging in. Okay.
So this is on your YouTube.
Y'all, while we are in the sidebar, I'm going to throw up our commercials for our sponsor who has kept me awake these early mornings. So let's show some love to our sponsor. Miss Diane. Yeah. Okay. Here we go. Let's show some love to our sponsor. Hey, y'all. I am so excited we have our very first sponsor, and I'm wearing this hat to honor them. Who is it? Well, it's coffee, my favorite thing. This coffee is from Hitchman Homestead Coffee. This is the Shooter Shack Coffee Pioneer Nicaraguan Roast. This coffee is so delicious, y'all. It is so smooth. It does not leave a chemical taste on the back of the tongue. It's not overly bitter. And I have to tell you, it is my favorite. And I am now getting rid of all my other coffee. I kid you not. They have a monthly subscription available. You get 12-ounce bag a month, either whole beaned or ground. And then you can also get a Keurig option as well. The other thing they have is wonderful gift boxes that you can send to your loved ones. So you want to support a fabulous home business And people here in the Hill Country, go to hitchmanhomestead.com and let them know I sent you, and grab yourself some of the best tasting coffee we have here in Texas Hill Country. So y'all, you want a membership, go and hop on and get your coffee every month, or you can just order it by the box, and it makes fabulous gifts too. So I'll be right back with you. Thank y'all. Hey, y'all, that is a big peeve right there on Ashley's mom taking the stand and not being released from the subpoena. According to Jules, they were not happy. No, they're not happy at all. And part of the thing is that means that she can't discuss any part of this case with her daughter. And if so, it could cause a mistrial. And, but now I'm wondering, is she standing back outside the courtroom with the daughter again with the side and saying, "Save my mom"? That was just so wrong. So CPS is obviously involved. We'll see what happens on that end. Okay, guys, I'll be right back.
All right, members of the jury, here's what we're gonna do. I'm gonna go ahead and let you go to an early lunch. It's about 11:20 right now. So the good news is you get to beat the crowds wherever you decide to go. If you could be back downstairs in that jury assembly room where you start each morning at 12:30. And we'll look forward to getting you back up here as soon as we can after that. Please remember, if you do go out somewhere and have lunch, if you go in a group, that's just fine. You can absolutely go in your groups, but do not discuss the case at all amongst yourselves or anything about the case. Don't talk about the case with anybody outside of the jury. And please don't do any legal research or research on the people, places, things, or legal topics we've heard anything about. Again, if you're sitting somewhere, you hear, just kind of hear in the din of the people behind you something about the case, just let them know, hey, I'm a juror in this case. I need you to stop. If they don't, if they persist, please leave and report it immediately to the deputies. All right. See you back hopefully around 12:45.
Well, y'all, that looks like it's going to be a wrap for this morning. Let's do this. I know I'm going to get a call in from Jules, so I'm going to go ahead and hop off screen and get that set up. But in the meantime, y'all grab yourselves something to drink, go to the little TT room and get back in
All right,
here
everybody,
and get
have a
comfortable?
seat. The jury's out. Ms. Murphy, we're going to take
That's
an early
Jules
lunch
right there.
break. I want to remind you that the rule of sequestration has been invoked, so you're not to discuss your testimony or the questions asked of you with anyone, including the attorneys. You're not to discuss your testimony with any other witnesses or talk about what their testimony was or will be. You're not to view anything about this case. All right, we'll see you back here. If you can also be here be back about 12:30.
Okay, no problem.
All right, we'll see you guys back here at 12:30.
Okay, guys. Everybody hang tight, Miss Diane, and let's see if we get a call from Jules when she leaves. She may be calling RA first, and then she's going to call us. So, in the meantime, I'm just going to throw on some music, and everybody take a breath, and I'll be back in about 5 minutes. So there's music going in the background.
And Jules is there.
Yeah,
Where are
that was
they
a
at?
woman in the white shirt. This is in Florida. So she's going to call me, and it's going to go through my phone. It'll go through here, and it'll be live on here.
Oh, wow.
So when we're doing makeup, I can take live questions.
Very cool. God, this sounded
I built this over time and got them on good sales. The screens are cheap. This is the fortune. And the camera, those are the expensive parts. I also have a GoPro that I can have another camera going. But I got to reconnect it because for some reason it's not happy. But they can see, they love to see my setup. People love to come in and hop in and see the setup. Let's see if we can get it playing. It's being a little finicky. GoPros are very finicky creatures. But let's see. Yeah, it's being finicky. I got to recharge that battery. So right now, I'm waiting for a possible phone call from her. She's going to be calling. Let's see if she's called Recovery Addict. See, that's what my camera looks like. That's what I look like. You see, she's on the phone with him.
Who's on?
Hello, are you still live? I just did it. Okay.
Hey guys, welcome. We have Miss Jules live. Oh my gosh, y'all. How are you doing, Miss Jules? Can you hear her? First of all, Miss Diane, can you hear her? Yes. Okay.
Everybody can hear me? Okay. I just got off the phone with RA. So now I'm calling you. I gave a shameless plug, Ada, for you. I told RA that approximately 7:30 Eastern Standard Time, I will be live on your channel to discuss today's events. So
Oh, you
everybody
are
over there
awesome.
knows. So everybody over there knows we're going live. Anyway, okay. Jury makeup. There's 9 jurors. 6 will be deliberating, so there's 3 alternates. They are 7 females and 2 males. The one male I'm going to say is in his 40s, and the other male is in his 60s. The 7 females range in, I'm guessing, early 50s to maybe mid 60s or so. They're not avid note takers. They do take notes, but not as rigorously as the Kowalski versus J-Hash jurors. As far as Ashley is concerned, you've never met Maya. I did when I was talking to RA this morning because he met Maya. Maya is very tiny and slight. Well, Ashley Benefield is very slight as far as bone structure and weight. She's tiny in that respect. But I'm going to say she's approximately 5'6" because I'm 5'3", and standing next to her, I think she had like 3 inches on me. I could be wrong, but yeah. But
wow.
The only reason why and I'll go into more detail tonight when we're live. The only reason why I'm saying that is because yesterday, it seemed like the prosecution was making a big deal out of what size shorts did Doug wear, what size shirt, and he was only 5'9", like trying to make it appear that he was a slight man. Well, she's a slight woman. And that's all I'm going to say for right now, Ada. Do you have any questions for me?
Yes, actually I do. What is the overall behavior of the jury in the courtroom other than the note taking? Are they watching her? Are they observing her behavior?
No. No.
How are they reacting to the witnesses?
They're stoic. I've been in many criminal trials before. I'm not even going to bring up Kowalski versus J. Hatch because that was my first civil case. I've been in many criminal trials before, and I have to honestly say that this is the first time that I've seen a group of people that they don't interact with each other. They don't look at each other. Like if there's some, like a shocking comment or an objection or whatever goes on, they don't even like take a side glance at each other. Only 2.
Sorry, go ahead. You're good.
2 women every now and then glance at, will glance at Ashley, but for the most part, their focus is on whether it's the prosecution or the defense attorney that's up at the podium. They're looking there. They will glance at the witness, but I got to tell you, like I told RA, this is the hardest jury that I've ever seen to be able to read because I'm really good when it comes to body language of a jury. And there's just, this is going to be a tough one, tough call. It's going to be it's going to be a tough one.
Wow. Wow. So what about the audience and them? People in the courtroom.
Doug Benefield's cousin is in the courtroom, and Doug Benefield's daughter is in the courtroom. Let me definitely clear this up for everyone that's watching. There were no protesters out in front of the courthouse when I got there. Her daughter is not there. Even during the lunch break, there has been no protesters out there. However, her pastor, I don't know if you could see, I'm going to say a younger looking gentleman on the defense side. He sits in the back row. He wears his hair in a ponytail, dark haired man. That is her pastor. And so he is in the courtroom. The people that are on her side of the courtroom, and I'm sitting there. I don't want anybody to think that I've taken sides here. I haven't. I just wanted to position myself in an area where I could see the jury and the witnesses. You know what I mean?
Definitely. So the lawyer is still on the stand, correct?
Yes.
Okay. So she's a breath of fresh air to this trial, I have to admit.
I don't like her.
Well,
I don't like her. I agree with the defense attorney. She's doing a narrative. She's pushing an agenda. She's getting stuff out there that is not allowed. And she did open the door. So this afternoon, I think you're going to see fireworks. That's my prediction. I think after lunch, things are going to get really spicy between her and the defense attorney. And during the first sidebar that they had in regards to her, she was smirking at the jury, which I found very inappropriate. During the second sidebar, she was not. She was just staring ahead. But yeah.
Well, you are awesome. Thank you so much, love. We were going to have a full night tonight. I will post the time and we'll talk about it when we get. What time your time?
I said 7:30. Is that good for you?
That's 6:30 my time. That's good for me.
Okay, I'll as soon as we get out of here, I'm going to race home, take care of Frankie, because this is the first time since the Maya trial he has been alone all day. So I got to do what I need to do, and then boom, yeah. All right. I hope I was helpful.
You
guys.
We'll see you tonight.
Okay. All right. Love you guys. All right. Bye-bye.
Wow, y'all. That is awesome. Okay, so that gives us time to hop off for lunch, and we will be back with a new live. Please come back and join us. Every time I cut a live, sometimes we lose some of you guys, and I understand, but I hope you come back. So with that, Miss Diane, thank you so much. Love you, doll. We'll see you in a little bit. Okay. Bye, hon. Okay, guys, we're going to exit out of here. Give everybody a chance to get some lunch. Get me some lunch. Let me say goodbye to my guest. You are awesome. I appreciate y'all so much. And I shall see you in a little bit. Bye. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.